In 1336, tell us your name, please.
I come in sui
Wow.
juris.
Only one of you actually has that phone number, and the other people are just wrong about what their phone number is. Who's calling ending in 1336?
Sui juris and personal persona. I'm Stephen hyphen Tyrell colon white comma beneficiary and sovereign. I'm here under fraud, menace, and duress. Fiduciary Daniel Williams Norbeck.
Okay, Mr. White, we're going to pop you over in the waiting room because you're just going to be a distraction for all the citizens here willing to abide by the laws of our country. So we'll pop you over in the waiting room and we'll get back to you. In case you guys have ever heard of the term sovereign citizen in the news, that's what one of them sounds like when they try to come.
Buckle up, guys. Today we are going to dive into a courtroom like no other, where sovereign citizens, self-proclaimed experts, and dramatic objections collide. Each clip reveals tension, confusion, and jaw-dropping moments of legal absurdity. Let's break down the most outrageous, suspenseful, and entertaining courtroom interactions you'll ever see.
You understand what you're charged with? This says that on January 7th of this year, on 2nd Street there in the city of Fenville, that you were driving while license suspended. That is a misdemeanor. It's punishable by up to 93 days in jail and or $500 fines and costs. Do you understand your charge?
Objection, Your Honor. I do not. I do not understand my charges or
okay. I'm going to mark you down as not guilty, and we'll set you for a jury trial. You can continue to.
Your Honor. Your Honor. You practice in front of bench. You practice in front of bench. That's my job or my attorney job. I'm sui juris. I'm pro pria person.
Okay, Mr. White, I don't know where you read the stuff that you're saying, but it's legal nonsense. It means nothing in a court of law. So if you're not willing to state that you even understand or recognize the authority of the court, my options are I can make you come in for arraignment and not give you a PR bond, and then you'll have to post bond to not sit in jail. You want to do it that way instead? Right now, if I get through arraignment with you, I'll give you a PR bond. Mr. White?
I don't listen. I'm asking you a question.
What's the question, sir?
I'm not arguing with you, Your Honor. I just want you to hear me. I just want you to hear me.
Okay, but I don't want to listen for 20 minutes. Go ahead and ask your one question, and we'll start there and see if it's a real question.
Am I on the record?
Yes.
It's not going to take 20 minutes, Your Honor. I give you my word.
Well, you said you have a question, sir. What's the question you want to ask?
Is this criminal or is it civil?
This is criminal, sir. It's punishable by up to 93 days in jail and or $500 fines and costs.
Hey, if it's...
The video kicks off by setting the stage with a mix of curiosity and chaos. Right from the start, we meet a group of sovereign citizens and Karens, promising a courtroom spectacle. The tension builds immediately as the audience realizes they're about to witness legal antics, bizarre claims, and confrontations that defy normal court expectations, making this intro a must-watch hook.
It's because this is just arraignment, sir. What you're talking about is trial. That would be several steps down the road. Arraignment is just for you to make sure that you understand what you're accused of, what the penalty is, and for you to enter a plea. You're accused of driving while license suspended. I read to you what the possible penalties are, and I asked you if you wish to plead guilty or not guilty at this time.
No, Your Honor, I'm a beneficiary and I'm a sovereign. I'm here under fraud, menace,
okay, sir. Those sentences don't mean anything. They have no legal meaning whatsoever.
It's guaranteed by my constitutional.
I've indicated that since you can't understand arraignment, I've entered a plea of not guilty on your behalf. I've set you for a jury trial. You can represent yourself free of charge, or you could hire an attorney. And now you must make a choice, sir, for bond. If we get through the arraignment with you on Zoom, I'm going to give you a PR bond, personal recognizance bond. That means you don't have to post any money. We're essentially trusting you that you'll keep coming back for your court dates. It is no driving without a valid driver's license. If you cannot get that far, in other words, if you really don't understand what's happening here, then I'm not going to allow you to be arraigned by Zoom. I'm going to set you for arraignment in person. And you will come to this courthouse. You will not get a PR bond. You will get a $300 cash or surety bond, meaning that you will need to post $300 in cash, or you will sit in jail from that day until your trial date. So I'll give you a choice. Do you want to be arraigned over Zoom like we're doing today, or would you like to come in and be arraigned in person?
Well, I object to all of this, Your Honor, because at this point, I don't even understand the charges. I do not understand the charges. I'm not trying to.
That's fine. No, sir, you're allowed to, sir, you're allowed to object, and I understand your sentence that you don't understand the charges. And so I will attempt to work with you for that for a second. I'm going to read the charges to you, okay? This says that it takes place on January 7th of this year. You understand that, right? The date that I just read.
I'm saying I do not. At this point, Your Honor, it's I was saying this. It was a jury.
Judge Norbeck wastes no time exposing Mr. White as a classic sovereign citizen. The courtroom dynamic shifts instantly as the judge balances patience with authority, highlighting the absurdity of Mr. White's claims. This is where viewers get a clear glimpse of how bizarre, confusing, and theatrical such interactions can become in a legal setting, setting the tone for everything that follows.
Here's the problem with you arguing jurisdiction. I am a lawyer, so I understand what jurisdiction means. I'm not sure you do. The accusation is that you're driving around on 2nd Street in the city of Fenville, meaning in Allegan County, and that you're doing so when your driving privileges with Secretary of State have been suspended or revoked. Because this is the county. Yes?
Objection. I'll travel. I don't drive.
Okay.
I have no contact.
Sir, here's what we're doing, Mr. White. You are no longer able to be arraigned by Zoom. What I'm going to do is adjourn this. I'm going to adjourn this, and you will get notice at your address there. You will come in, and we will arraign you in person. I'm telling you that I'm not going to give you a personal recognizance bond, sir.
It has to be. Before we can proceed,
White,
before you can proceed, there has to be a address, Your Honor.
Because we are on the record, I'm going to make this infinitely clear. You're going to get notice to appear in front of me. You have two choices. If you do not appear, I'm going to put out a bench warrant for your arrest. If you do appear, we will have this conversation again about arraigning you to see if you understand the charges, but you are not getting a PR bond. You will need to bring with you $300 cash or surety, or you will be in jail. Do you understand those two options, A and B?
That's a violation of my Constitution.
As Mr. White refuses to acknowledge the charges, the tension skyrockets. The judge methodically explains the arraignment process while Mr. White rambles in legal nonsense. The suspense lies in whether he will comply or push the boundaries further, keeping viewers glued. Every misstatement and misinterpretation amplifies the drama, perfectly showcasing the clash between law and illusion.
Well, no, it isn't, sir. So we're all set for today. We're done talking. We cannot make any progress. You will be asked to come in person for arraignment. You can either choose to come in for arraignment or you can choose to not be here. If you choose to not be here, a warrant will be entered for your arrest. And if you do choose to be here, make sure you bring that $300 because you're not getting a personal recognizance bond. But we are done with this hearing. I'm going to go ahead and release you. Thank you.
When's my date?
Bond discussions add stakes to the already volatile scenario. Mr. White's objections and insistence on misunderstanding the legal process creates palpable courtroom suspense. The judge's explanation of PR bonds versus cash bonds makes viewers realize the real consequences of defying court authority, and the suspense peaks as the audience waits to see whether compliance or chaos will prevail.
824-00390201. The people of the state of Michigan versus Tanea Nicole Tubbs. This matter is scheduled today for competency hearing. Appearances for the record, please.
Good morning, Your Honor. Elena Rozak on behalf of the people, P78815.
William Glenn, P36794 on behalf of Ms. Tubbs. Ma'am, state your name.
Beneficiary, Tanea Nicole Tubbs.
All right, Ms. Tubbs, you have a constitutional right to be physically present in the courtroom. Do you agree to waive that right and hold this hearing by Zoom?
I agree.
Okay, thank you. Council, I've received a report dated February 13th, 2025, authored by Andrew P. Sheff, licensed psychologist, consulting forensic examiner. Have you both had an opportunity to review that document?
Yes,
Yeah.
Your Honor.
Yes, Your Honor.
Do you both agree, stipulate to that being admitted as court's exhibit number 1?
Yes, Your Honor.
And that'll be marked and admitted as court's exhibit number 1. All right, and do you stipulate to its findings?
Yes, Your Honor.
Yes, Your Honor.
All right, then the court will find that it says opinion. It's my opinion that Ms. Tubbs is competent to stand trial.
Yes, Your Honor.
Okay, then it says at the last paragraph says, while I recognize the ultimate decision in this matter rests upon a judicial determination, it's my opinion that Ms. Tubbs was competent to stand trial at the time of this evaluation. You both stipulate to both of those findings?
Yes, Your Honor.
Yes, Your Honor.
All right, then the court will sign an order. Is she receiving medication? Is she?
She's in the Calhoun County Jail. I don't know yet.
Ms. Tubbs, are you receiving medication?
No, Your Honor.
No medication? All right.
No, ma'am.
And counsel, are either you aware that she's receiving medication?
I am not aware, Your Honor.
I am not aware, Your Honor.
I don't see any mention of medication here, so. All right, and I'm signing the order finding her competent to stand trial. And do we have a trial date on this matter?
March 17th.
What date?
March 17th.
Okay, so this matter is scheduled for March 17th at 9 o'clock. Has council had a chance to discuss whether this matter is going to be resolved or not?
Your Honor, I had filed a notice of insanity to get a criminal responsibility report. I have not received that yet. Once I get that, I'll have a good idea as to whether we're gonna be able to settle this or whether or not we have to go to trial.
Your Honor, I object on that. I would like to exercise my Sixth Amendment right, and I would like to reserve my rights to not be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, willingly, voluntarily, or intentionally. And I furthermore do not accept any liability of compelled benefit under any unrevealed contract of the commercial agreement. And that's under code UCC 1-207. And I have the rights to represent myself and waive all counsels knowingly, willingly, and
Switching gears, the focus moves to Ms. Tubbs during her competency hearing. Her status as a sovereign citizen again introduces tension, but now with added stakes over her legal capacity. As the court debates her fitness to participate, viewers are on edge, wondering whether she will be able to represent herself, highlighting the absurdity and suspense of self-determined legal competence.
All right. Well, then I'm going to voir dire you with regard to that decision. Would you like an opportunity to speak with your client in the breakout room with regard to this decision, counsel?
Well, she said that a couple of times, but I would ask that the court hold off on that till I get the criminal responsibility. So, you know, if once I get that, then if she wants to represent herself, then we can, you know.
Well, ma'am, do you want to do are you saying you're not going to do the criminal responsibility evaluation?
I do not need to do any of that, sir.
I'm sorry,
That's defamation of character. I will not be doing any of that. And I would like to exercise.
You are requesting that you not do a criminal responsibility evaluation. Is that my understanding, ma'am?
That is your understanding. Correct.
Well, yeah, with the MIDC's policy, I don't know if I can continue as her attorney of record. She has to have standby counsel appointed if she's going to represent herself. That's my understanding of their current policy.
All right, and you do standby counsel?
No, yeah.
All right, well, I'm going to Would you like to talk with her before she makes this decision? I'd like to have you
Okay.
speak with her.
Yes, Your Honor.
So, ma'am, I'm gonna have the attorney go into a breakout room with you and just talk to you. This is a very important decision. I'm not saying I'm not gonna do it, but I just want you to talk with him and understand some of the risks of doing this. And, okay?
Your Honor, I understand all the risk and I do not wish to talk to him.
Ms. Tubbs' bold request to self-represent escalates the drama. She rejects counsel and insists on controlling her defense, creating suspense as viewers anticipate the consequences. The courtroom becomes a tug-of-war between her confidence and the legal reality, while the judge patiently outlines the serious risks, making this one of the most intense moments in the video.
Talk with him, is that correct?
Correct. I understand all the consequences and repercussions in this case.
Okay, all right. Then let's, ma'am, we're gonna need you to have you sworn in for you to self-represent yourself, okay? I want to ask you some questions, just so you understand. Can you swear her in, please?
Ms. Tubbs, please raise your right hand in front of the camera where we can see it.
I do not swear in, but I wish to tell the truth and nothing but the truth.
All right, then will you affirm?
I
can
am
affirm.
here to, I'm here
All
to
right,
reserve
let's
my
have you
right.
raise your hand and you can affirm, okay?
Do you solemnly swear to?
No, do you
affirm?
solemnly affirm?
Do you solemnly affirm to tell the truth and nothing but the truth, so help you?
I tell the truth and nothing but the truth.
Okay, you have to put your right hand up, ma'am, please. Let's do it again.
That's against my religion, sir.
All right, then ma'am, I'm not gonna have you self-represent you until you do this. So if you're not gonna do it, we're gonna continue the attorney with you, all right? So you tell me what you want to do, Ms. Tubbs. Because until I go through these questions with you under oath, we're not signing any, we're not
But I need to
having
know
you
what
present
oath,
yourself.
what oath am I going under, sir? I have the right to know what oath I'm going under because I don't go just under any oath.
All right, well, let's have her raise her hand again and you say the affirmation. It's not an oath, it's an affirmation. Raise your right hand, please, ma'am.
Do you affirm?
No, yeah, okay.
Do you affirm to tell the truth and nothing but the truth, so help you?
I tell the truth and nothing but the truth, and I come in as beneficiary, affirm.
All right, thank you, ma'am. What's your name?
I am the beneficiary, Tanea Nicole Tubbs.
All right. Do you understand that you have a right to have a lawyer represent you in this case?
Yes, sir.
Do you understand that I will appoint a lawyer to represent you if you cannot afford a lawyer?
I waive that right.
Huh?
I understand what you're saying, but I waive that right.
Okay. Do you want to have a lawyer represent you?
No, sir.
Can you afford a lawyer?
Yes, sir.
Okay. What is the maximum sentence in this matter, Madam Prosecutor?
In this matter, Your Honor, it is
Punishable up to 5 years or a
It's-
fine not.
Ma'am, just wait. Let me speak, okay?
I'm
Madam
sorry.
It would be 7.5 years because the defendant, it's carrying concealed weapon, which is a 5-year maximum penalty, but there is a habitual second offense notice. So that would increase the penalty to 1.5 times the maximum sentence, which would put it at.
The oath and affirmation conflict brings another layer of drama. Ms. Tubbs refuses to comply with traditional court procedures on religious grounds. The suspense builds as viewers realize her decision could halt or complicate proceedings entirely, revealing the tension between personal belief and legal obligation in a way that keeps everyone riveted.
Matter is 7.5 years because you are a habitual offender second offense notice. So it's 7.5 years is the maximum sentence. Would you like to talk with a lawyer, with a court-appointed lawyer to decide if you want to represent yourself or not?
No, I would like to represent myself and put in the motion to dismiss.
Okay, so ma'am, first of all,
With the maximum sentence explained, the stakes couldn't be higher. 7.5 years hang in the balance, yet Miss Tubbs remains determined. This section underscores the absurdity of self-representation and the real-world consequences at risk, creating suspense that feels almost cinematic, as viewers grapple with whether confidence or reality will prevail.
College.
college, okay. And have you represented yourself before?
Yes.
And why do you wish to how many times have you represented yourself?
Twice.
Okay, and then what were those in criminal matters?
One is, yeah,
And what happened with that case?
I got it dismissed.
Okay. And what was the other case you represented yourself, Ms. Tubbs?
I'm actually doing that now. It's for another criminal case, actually.
And you're representing yourself in that case?
Yes.
And why do you wish to represent yourself in this case?
I wish to represent myself in this case because I have learned all the trade secret acts, and I'm fairly fed up with how this courtroom is operating and suing people without letting them know that they are entering into a contract with you all as owning our vessels, and I'm tired of it. I'm tired of it. No one owns me.
All right, ma'am, tell me what the elements of this offense are.
The elements of this offense is that it's punishable by imprisonment for more than
No, that's not what the
Oh.
the elements of the offense are.
The elements? What do you mean
Yeah.
by elements? Because you know y'all.
Well,
use double
that's the problem. You
Y'all
don't
use
know.
double language here, so I know.
How are you going to represent yourself if you don't even know the elements of the offense? How are you going to do that, ma'am, if you don't even know what you have to defend against?
I have to offend against the accusations, the charges.
All right, ma'am, tell me what the rules of, do you know the rules of procedure?
The rules and procedures to this is
Yeah.
that a prosecutor, the people of the state of Michigan is trying to sue my corporation. That's correct, right? And you are acting as a trustee, correct? Y'all acting as judges and acting as trustees, correct?
No, I'm elected as a judge. I'm not a trustee. I'm a judge, okay? Ma'am,
Okay, so what?
ma'am,
so
no,
what-
you don't get to quiz me. Ma'am, what do you know what the rules of evidence are?
Yes.
Okay, tell me what the exceptions to the hearsay rule are.
The legal knowledge test exposes gaps in her understanding while she tries to impress the court. The judge quizzes her on rules, evidence, and procedure, and the audience experiences the clash between overconfidence and ignorance. Each misstep heightens the tension, making this one of the most entertaining and dramatic segments of the video, keeping viewers hooked.
So
You got acceptance of hearsay, sir. I would like to write everything you're saying down so I can
Have you ever done jury selections or jury instructions?
Yes, jury, it holds up to 12 people.
No, do you know how to ask them questions?
Yes.
And how to do the jury instructions? All right. Do you know how to preserve issues for appeal?
Yes.
Do you know that self-representation is almost always unwise?
Yes.
Did you know that the first day of law school, they tell us that he who represents himself has a fool for client? Do you know they tell us that?
Yes.
And so what does that tell you if they say he who represents himself has a fool for a client? What's that tell you, ma'am?
You know what it tells me?
Yeah, what's that tell you?
You all operate in trade secret acts. So
Okay.
You
Well,
will be
that's not
approved.
true, but okay. Ms. Tubbs, would you do brain surgery on yourself?
Why would I do brain surgery on myself?
Yeah,
The legal knowledge test exposes gaps in her understanding while she tries to impress the court. The judge quizzes her on rules, evidence, and procedure, and the audience experiences the clash between overconfidence and ignorance. Each misstep heightens the tension, making this one of the most entertaining and dramatic segments of the video, keeping viewers hooked.
okay. You understand you'll receive no special treatment and you can receive no help from the judge during the trial. You understand that?
I understand.
You understand the prosecutor is an experienced trial lawyer who is unlikely to give the defendant any special consideration. Do you understand that?
Yes,
You understand you'll receive no special help from the court staff and you'll be expected to follow the same requirements that apply to practicing lawyers. You understand that?
yes,
Madam Prosecutor, have I complied with MCR 6.005?
Yes, Your Honor.
All right, ma'am, do you believe that your waiver of an attorney is knowingly, intelligently, and voluntarily made
correct.
and accurately and understandably?
Yes,
Then the court will find that the waiver is knowingly, intelligently, voluntarily made. The waiver is unequivocal. You understand the disadvantages of self-representation, and self-representation will not disrupt, unduly inconvenience, or burden the court. So I'm going to grant your request to represent yourself, ma'am, okay?
thank you.
All right. Now we've got a jury trial. What's our date?
And I would like the full discovery package sent to me, please, as well with along with the Dr. Chef report.
Can you
And
get-
The court reluctantly grants self-representation, introducing the concept of discovery and standby counsel. Viewers feel suspense as the judge sets strict conditions while she tries to assert control. The interplay of authority, risk, and dramatic irony shows just how fragile and chaotic courtroom proceedings can become when someone insists on ignoring experienced advice.